Breaking news out of the United States Supreme Court. I've taken a look at the briefs submitted by the state of Illinois and the city of Naperville in the Illinois assault weapon and the magazine ban case out there. I've read their briefs carefully. Let me tell you what I think and what I think the Supreme Court's going to do when they read them themselves. Stay tuned. We'll talk about it when we get back. Hey folks, I'm Mark Smith, host of The Four Box of Down, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and proud author of the brand new best-selling book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check that book out. It's really written for Americans to vindicate our founding fathers and their wisdom to ensuring that we had armed citizens here in America who were proficient in firearms, something the Ukrainians did not have, and they paid a price for that, obviously, with the Russian invasion. Okay, folks, yesterday I covered the Paul Clement Aaron Murphy brief for the National Shooting Sports Foundation quite extensively. It was a very powerful brief. It is a winning brief. I've now looked at the briefs by the state of Illinois and the city of Naperville in the United States Supreme Court, what they filed in opposition to the Clement Murphy argument and also in opposition to the paper submitted by the excellent attorneys for the National Association for Gun Rights. Having looked at all the papers, I think there is one critical potential problem for the Second Amendment movement. I think everyone understands this. I flagged this from the beginning, which is the procedural posture of this case. Specifically, the United States Supreme Court, as a general matter, prefers to hear cases and opine on them after the entire case is over, when there's a final judgment and all the appeals have been exhausted and all the arguments have been made and all the evidence has been submitted. Then the Supreme Court likes to generally get involved. They generally do not like to get involved in what are known as interlocutory appeals, which means appeals that are in the middle of a case. This case involving the National Association of Gun Rights is exactly that. It is in the relatively early stage of the case, and it's on seeking a preliminary injunction for the duration of the litigation. So usually the Supreme Court would not get involved with the case in this situation. With that said, this is kind of an extraordinary situation where it's pretty clear to all involved that the state of Illinois and the city of Naperville are looking for opportunities to thumb their nose at the NYSERDA versus Bruin of the Supreme Court and the Second Amendment jurisprudence. So I do think there's a chance the Supreme Court might get involved. But the best argument by the defendants in this case against the Second Amendment plaintiffs is, again, the procedural arguments that say that the Supreme Court never gets involved at this stage, and they should not get involved at this stage. They should let the case play out in the lower courts for the next year or so before they consider getting involved. And that is probably, to the extent we're going to lose or something bad will happen to us in the Supreme Court, that will almost certainly be the major reason why. With that said, it is not a guaranteed loss by any stretch of the imagination. So let's talk about the substantive arguments that Illinois and the city of Naperville made in this case. To begin with, the city of Naperville's brief overall is pretty weak tea, in my opinion. It's not very strong. It was written by a prominent law firm as well as a nonprofit organization, the Brady Center to Prevent Gun Violence. Apparently, they stepped in to represent the city of Naperville in this argument before the U.S. Supreme Court. And the reality is they made very good arguments on the procedural posture point I just made, but beyond that, the rest of them were mostly appeals to emotion and things that are not relevant to the Supreme Court. As you know, when you're dealing with a gun ban case, which this is, the only question is whether or not the arms or the guns that are being banned by someone are in common use by Americans for lawful purposes. There's no dispute at the end of the day that the semi-automatic rifles that are being banned, or their sale is being banned, or the magazines that hold more than 10 rounds or more than 15 rounds are in common use. And remember, it's not the burden of the plaintiffs who support the Second Amendment to prove they're in common use. It's actually the burden of the government to demonstrate that these items are not in common use. But let me continue on. Some of the reasons why it's pretty clear that the city of Naperville brief is weak tea is they, of course, lead off with the typical stuff, appeal to emotion, dealing with mass shootings. No one likes mass shootings, but that is besides the point. And this is a critical point I want you to understand. These anti-gun arguments and these government arguments against the Second Amendment, they seem to think they can get traction by virtue of talking about these mass shootings, as if this is something new. Unfortunately, violence at this level is not new in American life. Specifically, it's not new in the context of cases coming before the United States Supreme Court. What do I mean by that? Keep in mind that the United States Supreme Court decided the Heller versus D.C. decision, saying that the Second Amendment protected the individual right to bear arms, and that individuals had the right to a loaded, unlocked handgun in the home for the purposes of all lawful purposes, including but not limited to self-defense. And that was the holding of Heller. Now, Heller was in 2008. And why is that important? That's extremely important for these arguments because in the year of our Lord 2007, you had the terrible mass shooting that took place at Virginia Tech, where a student used multiple, I believe it was 2 pistols, 2 handguns, to murder many students at Virginia Tech. And yet a year later, the Supreme Court overlooked that, saying that it doesn't matter because under the law and the text of the Second Amendment, those sorts of interest balancing arguments, those appeals to emotion, those legitimate concerns, but none of that has anything to do with describing and protecting the right to keep and bear arms for lawful Americans who are not, psychopathic criminals who have misused firearms. So again, these discussions of all the stuff that's occurring against guns in the wake of mass shootings is not going to be persuasive to the Supreme Court because, again, if it were to be persuasive, we would have lost the Heller case in 2008 because it followed on the heels of the 2007 Virginia Tech massacre. It obviously does not affect our rights because we do not define rights. We do not define rights in America under the Second Amendment or any of the Bill of Rights by virtue of how they get misused by miscreants. That's not how we do rights in America. The bill brief then goes on to try to appeal to authority with lower courts, but you know from this channel that lower courts, meaning courts below the Supreme Court of the United States, are considered inferior courts. That's not my language. That's from Article 3 of the United States Constitution, and I can assure you that the Supreme Court does not have any real interest in what lower courts say about anything involving the Second Amendment or really for much of any of that, because they are able to make their own decisions about what the law is. The next point interesting about the City of Naperville brief is both them and the state of Illinois made a strategic mistake that's pretty clear in my point. What is one of the Mark Smith rules at the Four Boxes Diner when you're dealing with a gun ban case or a case involving AR-15s and you're trying to get rid of them? The rule is this: if you do not cite, if you do not quote, if you do not discuss or distinguish the United States Supreme Court decision in 1994 of Staples versus the United States, which drew a clear distinction between ordinary semi-automatic AR-15s versus so-called machine guns or machine guns. In both the brief from the City of Naperville as well as the brief from the state of Illinois, neither mentions the Staples case. To me, this is a strategic mistake on the part of the anti-gunners. I don't know why they didn't go there, but this is a clear Supreme Court precedent that draws that distinction between machine guns and semi-automatic rifles, and all this discussion in these briefs by the City of Naperville about quote-unquote assault weapons or quote-unquote weapons of war and trying to compare AR-15s to M16s goes nowhere when they can't even be bothered to cite to the critical authority of Staples versus the United States. And I can assure you, if Mark Smith at the Four Boxes Diner understands this as a problem, I can promise you that the United States Supreme Court Justice and their very smart law clerks are going to see this instantaneously. Again, the City of Naperville appeals to authority. They say, quote, this is not an accident about talking about mass shootings using quote-unquote assault weapons. They say, quote, assault weapons were originally created as weapons of war during the Cold War. When AR-15s were tested on the Vietnam battlefield, they were deemed ideal because of their excellent killing power and their capacity to rip human bodies apart, period, close quote. Again, the Supreme Court is not going to be interested in this because they've already ruled out any kind of interest balancing, both in Heller and also in Bruin. And again, yet again, the Supreme Court would be much more interested in having these lawyers try to distinguish the Staples precedent, which cuts dramatically against the anti-gun movement, and trying to make this comparison that says M16s and AR-15s are really the same sort of weapon, because Staples, Supreme Court on-point precedent, says that is clearly not true. The next big argument by the City of Naperville is they try to argue that all they're really doing is banning the sale of these so-called assault weapons. And they try to say that, well, the Supreme Court allows for the regulation, and this is the key word, for the regulation of these kinds of weapons. But here's the kicker. Regulation is not a ban. Let me say that one more time. Regulating something is not banning it. If I regulate how you make cheese, I say things like you can only work 9 to 5, or maybe you have to use proper signage, or you have to disclose the amount of milk you use in the cheese product. That is regulating cheese making, for example. Saying that no one can sell cheese or no one can buy cheese is a ban on cheese. So too, and this is both the case for the Naperville brief as well as for the Illinois brief, they're both trying to conflate laws and analogs dealing with regulations of a process or regulations of a sale or regulations on a product with actually banning it. They're not analogous in any respect. And again, here you go in the Naperville brief where they specifically are talking about this issue dealing with regulation, but they're not dealing with regulation in Naperville or in the state of Illinois. Those are absolute bans. So overall, the City of Naperville brief I don't think is particularly persuasive. I think it's mostly an appeal to emotion, and they make some good procedural posture points the Supreme Court is well aware of. But beyond that, I don't think there's a lot to worry about in that brief. Now let's move to the state of Illinois brief. Again, terrible blow by the anti-gun movement to their cause as I see it with this brief because they failed to cite the Staples precedent. I think that is, again, a sign, and I'm looking at the table of authorities here, no reference to Staples versus the United States. They should have cited to that and dealt with it. They did not bother to do that. That, I think, is something the Supreme Court will take note of and will not look fondly about. I will note one other thing, that Paul Clement's brief for the National Shooting Sports Foundation specifically does talk about the Staples case because Paul Clement actually is a very experienced Supreme Court litigator and understands these basic things, and I think it was wise to cite that case in this instance. I should note that any arguments that these AR-15 style firearms with these magazines of more than 10 rounds are somehow useless or utterly no purpose whatsoever is just completely destroyed on page 3 of the Illinois brief because they point out that they have exceptions for the use by law enforcement, members of the military, and other professionals with training and so on. So the point is, obviously, Illinois is admitting these things have tremendous value because if they had no social value, then why are they letting their law enforcement agents use them? And by the way, although I don't know this with personal knowledge, there's no doubt that the United States Supreme Court justices have ample armed security. That's my best guess. I'm pretty sure I'm right about this. And I would like to bet dollars to donuts that the reality is some of those security officers, protected Supreme Court justices have maybe AR-15s in tow to make sure those justices stay alive from the threats. Keep in mind that Brett Kavanaugh was specifically targeted for an assassination in the spring of 2022 after the Dobbs opinion leaked. We must never forget that these justices are at real physical risk in today's environment, which is a terrible thing that which is a terrible situation that we now have to live through and that they have to live through, but that is just the reality on the ground today right now. None of this matters because, as the Supreme Court has said in Heller, Bruin, and Caetano, the only thing that matters is, are Americans using these types of firearms for lawful purposes? And by use, it just means to commonly possess. That's all it means to possess. They don't have to pull the trigger. They don't have to do anything but own them. I'll give you 2 examples right here, right now. First of all, in the Heller case, this is what the Supreme Court wrote about the fact that Americans owned handguns. They said specifically, whatever the reason, this is a quote, whatever the reason, handguns are the most popular weapon chosen by Americans for self-defense in the home, and a complete prohibition of their use is invalid. You see what I just said there? The Supreme Court also in Heller goes on to say that there's a bunch of reasons why a citizen might prefer a handgun for home defense. They give a list of these things, but at the end of the day, they say, for whatever the reason, again, whatever the reason, this is what Americans want. This is a hugely important legal finding by the U.S. Supreme Court in Heller. And why is that? Because it's not about, and unlike what Illinois is trying to argue here, is that they're trying to say that we get to decide how Americans defend themselves with firearms. The Supreme Court has said in Heller that Americans get to decide how they protect themselves and their families. And that's why they say, whatever the reason, for whatever the reason, rational or otherwise, Americans have selected handguns for the purposes of self-defense, and therefore they are protected under the Second Amendment because they're in common use today. Keep in mind, in the Caetano case, Justice Sam Alito, in concurrence, specifically says, quote, the pertinent Second Amendment inquiry is whether stun guns, remember, Caetano was about whether or not the Massachusetts ban on stun guns was constitutional. The answer was no, it was not. Why? Because they are obviously in common use. Here it is. Quote, the pertinent Second Amendment inquiry is whether stun guns are commonly possessed. Did you hear what I just said, folks? Listen very carefully. Samuel Alito, Justice of the Supreme Court, concurrence in Caetano 2016. Justice Alito said in the concurrence in Caetano, this is the key quote, quote, the pertinent Second Amendment inquiry is whether stun guns are commonly possessed by law-abiding citizens for lawful purposes today, period, close quote. Two key phrases here by Justice Alito. One is commonly possessed. They don't have to be commonly fired. The firearms don't have to be commonly shot. They don't have to be commonly used to shoot somebody in self-defense. They don't have to be commonly done anything with. They simply have to be, quote, commonly possessed by law-abiding Americans. And what time period is relevant? We see all this stuff in the state of Illinois talking about old statutes and old laws and old guns and all this stuff, and it's fun to talk about, the history of firearms, to talk about the Girondoni air rifle that Lewis and Clark took with them west that shot over 20 rounds. It's all fun stuff, but the truth is, as Justice Alito said in Caetano, here's the key word: today, today. The pertinent Second Amendment inquiry is whether stun guns are commonly possessed by law-abiding citizens for lawful purposes today. Period, close quote. That means the question is, today, in the year of our Lord 2023, are these AR-15s and these semi-automatic rifles in common use today? And are these magazines that hold more than 10 rounds in common use today by Americans for lawful purposes? The answer is yes, they are. Now, let me show you why we know that. Because you see, Justice Alito went on to talk about why stun guns were in common use in America in 2016. This is very important. Justice Alito rejects the state of Massachusetts' argument that says that handguns are, the number of tasers and stun guns is dwarfed by the number of firearms, and therefore stun guns are not protected. That was the Massachusetts argument by the Massachusetts Supreme Court. Justice Alito rejected that outright as absurd. He goes on to say that, quote, this observation that tasers and stun guns may be dwarfed in number by firearms, this observation may be true, but it is besides the point. Otherwise, the state would be free to ban all weapons except handguns, because handguns are the most popular weapon chosen by Americans for self-defense in the home. This is hugely important, folks, because Illinois argues in their brief that the better weapon to use for self-defense is handguns, and therefore they can ban long guns like the AR-15 rifle. But here you have Sam Alito specifically rejecting that notion that says that is absolutely not the case. And then Justice Alito hammers this home and wins the case, I think, for the Second Amendment on this point. Justice Alito goes on and says the more relevant statistic, as opposed to comparing the number of rifles with the number of stun guns, with the number of handguns, right? He says, quote, the more relevant statistic is that hundreds of thousands of tasers and stun guns have been sold to private citizens. He then quotes a series of things, including authority that says that there are approximately 200,000 civilians own stun guns in 2009. Did you hear what I just said? Is Justice Alito talking about people that pulled the trigger and zapped someone with a stun gun to figure out if they're in common use? Is Justice Alito talking about the number of times stun guns are used to save lives or take lives? No. Totally irrelevant. All he talks about is that there are hundreds of thousands of tasers and stun guns that are sold to private citizens, and that there are approximately 200,000 civilian-owned stun guns in 2009. Do you think there's more than 200,000 AR-15 style firearms in the United States and AR-15 style rifles in the United States and magazines that hold more than 10 rounds? Do you think there's more than 200,000? Yes, there are. And don't trust me. I'm not even going to trust you. You supporter of the Second Amendment, because in the brief of Illinois itself, they've admitted that there are millions of these AR-15 style firearms in America. That is an admission by the state of Illinois, of which they have no choice but to admit that. And keep in mind, Illinois is trying to say that the Second Amendment proponents, the Second Amendment plaintiffs, have to prove that these magazines and these AR-15 style firearms are in common use. But that's not true. Ding, 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 ding. Wrong. Keep in mind that the burden of proof is on the government, the state of Illinois, which means that the state of Illinois has to prove, which is impossible, of course, but they have to prove and meet their burden that AR-15 style firearms and AR-15 style rifles and magazines that hold more than 10 rounds are not in common use by Americans. They can't do that. It's impossible. So what they try to do is they do this sleight of hand that we've talked about on this channel repeatedly. And I warned everyone on this channel, and everyone who's watched this channel knows this, because I'm making you the smartest people in the room. No matter who's in the room with you, I will make you smarter than they are. The anti-gunners and the government defendants are trying to convert the in common use test, which as you can see is all about just owning. It just means possession arms, possessing or owning, nothing more than that. But if you look at the Illinois brief, they're trying to say that the Second Amendment plaintiffs have the burden to show that these weapons are commonly used for self-defense by showing that they're actually used in common sense by pulling triggers and the like. That is not the standard. I've just demonstrated by virtue of quotes from the Supreme Court. Right? There was no discussion in Heller about how many times people pulled a trigger in self-defense using handguns. There was no discussion of the number of people who saved their lives with handguns in Heller before handguns were viewed as protected under the Second Amendment. The only point there was that people own these in large numbers. That was all it took for in common use. The same as stun guns in Caetano. And it will be true also for AR-15s. Now, of course, just to be clear, the sleight of hand that the anti-gun movement is trying to make, and the state of Illinois is trying to make here, is to conflate the Heller test of in common use with the Bruin discussion of self-defense. But remember, the reason why Bruin talks a lot about self-defense is not because they're amended the in common use test or the in common possession test of Heller. It's that they talk a lot about self-defense in Bruin because the entire question presented in Bruin was whether or not those two individual plaintiffs who wanted to be able to carry a gun outside the home for self-defense. The whole question in that case was whether or not they had a constitutional right to carry the gun outside the home for self-defense purposes. So therefore, the Supreme Court used the phrase self-defense repeatedly, not because they were amending or changing the holding of Heller. In fact, they reaffirm Heller repeatedly and say how much they love the Heller case in the Bruin decision. But they talk about self-defense in the context of the Bruin case because that was the issue presented by the plaintiffs in Bruins who said, we want to carry handguns outside the home for self-defense. That's why the Supreme Court talked about self-defense, not because they were amending Heller in any respect. It was because that was what was presented in that particular case and nothing more. But the anti-gunners and the state defendants are trying to conflate the two to say that, oh, well, Bruin amended the Heller decision, so now the Second Amendment plaintiffs have to show more than in common use or in common possession. They have to prove that these arms are commonly used for self-defense by actually shooting people or actually defending themselves. And because that can't be done, because obviously self-defense activities are relatively rare in society, thank God, therefore they're not protected. But that's absurd, and that is clearly not what the Supreme Court has said in the past. Just to show you how the state of Illinois has actually proved the case that these firearms that are being banned and are in common use is on page 17. Illinois writes in their brief that there are, quote unquote, only 6.4 million gun owners and 2% of all Americans who possess assault weapons. Okay, so they've admitted on page 17 of their brief that 6.4 million gun owners own, quote unquote, assault weapons. Now, I just gave you the information from Caetano about 200,000 stun guns. I don't think you have to be a math major in a PhD program at MIT to know that 6.4 million Americans owning quote-unquote assault weapons is a bigger number than the 200,000 stun guns talked about in Caetano. And remember, Caetano and Heller only talked about mere possession, and nothing more to qualify for protection of an arm under the Second Amendment, and thus it cannot be banned by places like Illinois or the City of Naperville. Now, I do want to point out something funny in the Illinois brief on page 21. Remember, in the Heller case, the argument was that D.C. got to ban handguns because they let people in D.C. have long guns. So essentially what D.C. was arguing in the Heller case and the anti-gun movement, Heller was arguing that handguns are bad, long guns are good. That was the position in 2008 by the anti-gun movement. Handguns bad, long guns good. But guess what? They've now flipped that order because here is what Illinois argues on page 21 of its brief. It says, quote, it is widely accepted that handguns and shotguns which remain legal to manufacture and sell in Illinois, are preferable for self-defense. Did you hear what I just said? Here you have Illinois saying that it is widely accepted that handguns and shotguns are preferable for self-defense. So again, in contrast to Heller, which is handguns bad, long guns good, here you have the reverse. They're saying handguns are good and rifles are bad, right? But of course, that is not legally acceptable. And why do I say that? It's because what the United States Supreme Court said in Heller. Let me read this to you. Quote, it is no answer to say, as the District of Columbia does, that it is permissible to ban the possession of handguns so long as the possession of other firearms, i.e. long guns, is allowed. You see what I just said there? In Heller, the Supreme Court says it is not an argument to justify banning handguns for the government to come forth and say, but they can have other guns. They can have like long guns. They can have rifles. They can have shotguns. No, the Supreme Court has already rejected that type of reasoning. And therefore, when Illinois, which they do on page 21 and 22, say, hey, no big deal. People in Illinois, they still get to have shotguns. They still get to have handguns. So who cares if we take away their semi-automatic rifles? No, because Heller on page 57 of the decision specifically says that kind of argument doesn't work. The last point I want to make is, again, the state of Illinois tries to say that they get to engage in historical analog work, but there's two reasons why they can't. The first is the Supreme Court has already done the text, the history, and the tradition analysis in American law as to when a government can ban a firearm, or can ban an arm. They did that analysis in Heller and came up with the in common use test, which again, if a firearm or any kind of an arm, including stun guns, are in common use or in common possession, they cannot be banned. So there is no redo, there is no re-argument about all this stuff because the Supreme Court has already resolved that, set forth the standard, and now it just has to be followed and applied. Beyond that, there's an attempt by the state of Illinois to try to talk about unprecedented social change and that the analogs get to be more nuanced if you're dealing with something that has never occurred before. There's some sort of technological advance, but that is not going to save the anti-gunners. And I'm going to get a little geeky here, just slightly, but you'll understand what's going on here. What the anti-gunners and the state of Illinois argue here is, quote, whether the two regulations are relevantly similar, meaning is the modern-day gun control law relevantly similar to a historical analog? And if so, then they can argue that the modern-day gun control law is constitutional under the Second Amendment. But here's the key point. All of the laws that the Illinois lawyers have set forth in their brief that I can tell involve the regulation of firearms, like can you carry it concealed? Can you carry it open? These are regulations about how you do something. None of the regulations or laws that they've been able to come forth with in the relevant time period deal with actual bans, banning arms, banning the sale, banning the purchase of a particular kind of arm. As a result of that, those cannot possibly be, quote unquote, relevantly similar. So when Illinois says the question is whether or not the historical regulation is relevantly similar to the modern day gun control law, it is impossible for regulations in the past to give rise to a ban today, because a ban on an arm cannot possibly be relevantly similar to simply regulating a product or an item that is not banned. Those are completely dissimilar, and those analogs cannot function as legitimate historical analogs to one another. And yet again, none of this matters because the Supreme Court has already done all this historical spade work. They've already done the work, come up with the in common use test in Heller, Caetano, and reaffirmed it in Bruin. And that's all that needs to be applied here. And in that case, there's no real way for the anti-gun movement or the state of Illinois or the city of Naperville to win. Again, I think what's going to happen here at the Supreme Court, I still think if you're a betting person, the Supreme Court is likely not going to do anything dramatic here because of the procedural posture of the case, because the case has not been completely completed. It's not to a final judgment. The Seventh Circuit Court of Appeal has not fully heard the case and issued an opinion. So I think there is still a very good chance the Supreme Court is not going to act right now on the grounds that this is simply premature and they're going to want to wait for a final adjudication. But on the other hand, this seems to be such a clear and easy case that I could see the Supreme Court doing something in support of the Second Amendment in this particular context, but only time will tell. Okay, folks, I hope you learned a little bit something here today about the anti-gun arguments and the arguments by the city of Naperville and by the state of Illinois in this case here before the Supreme Court. And if you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.